Ruiz Faraj, case number 25-04128-DO. Present in the virtual courtroom, we have the plaintiff and his attorney, Mr. Block. We have the defendant and her attorney, Ms. Wolfram. We are here on the plaintiff's motion to enter the judgment of divorce. I have read both the motion and the response, as well as the defendant's motion to set aside the agreement, the settlement that was placed on the record. Mr. Block, I will have you go first, and I have read everything.
Very good, thank you. This court is aware because you were part of the what happened at the bench trial or the settlement, what ended up being a settlement on March 23 of 2026. There was lengthy negotiations with Attorney Van Dyken and myself and the parties. I think we spent a couple of hours that morning. I think we met with Your Honor twice, trying to work out, we had two competing appraisals at the time. What is the value of the house, because defendant was seeking to potentially refinance it. And I know we met with you about a couple of other things as well. I think one of them was the how much to award or to value the pain and suffering award from the defendant's auto accident. Long and the short of it is we reached a settlement on some very thorny issues, particularly related to the tax debts that the parties owe for a number of years. As you may or may not recall, there's about $74,000 owed to the federal government. The state is owed around $10,000 and has put several liens on the marital home. And what Ms. Van Dyken and I worked on at length that morning was trying to come up with a way of resolving it so these parties could walk away from this and truly be divorced. The IRS doesn't care who pays it. It's joint several. And originally what my client wanted to do was to sell the house and then pay the debts. And that was one of the things that I think, in fact, I know ended up in the judgment. The defendant wanted to potentially try to refinance the house, and then we came up with quite a lengthy discussion of how that was going to happen, where the money was going to go, how the taxes were going to be handled. Because in this case, there are no children, there are no other assets. You have tax debt, and you have a marital home, which is worth somewhere between $250,000 and $330,000, depending on which appraisal you use. I don't think we came up with what I would call a comprehensive settlement of how we were going to get this done, so the parties could be divorced and move on. What I would call a global resolution. Thereafter, as I stated in the motion, I believe Ms. Van Dyken was fired. I prepared a judgment, which I've attached to the motion, 12 pages. It's pretty detailed as far as the taxes and the years and what's going to happen. And this judgment needs to be entered. It has been over a year now since this matter was filed. I've read the responses filed by the defendant herself and by her counsel. This is nothing new. This tax situation, parties have known about for a long time. The defendant knew that she worked at the business for 15 years. She helped write checks. I mean, for her to come and say I didn't know about them is just simply, I don't think, real credible. To come in now and say, well, I didn't know about the taxes, or that there was, back taxes owed. That there was liens on the house. This was all disclosed in lengthy discovery. As far as the liens on the house, the summer tax bill, it would have been mailed directly to the house she was living in, for heaven's sakes. If you look and read through the judgment, She gets 52.5% plus 25,000 in alimony. If if the house is sold. I mean, this was not a flippant or a casual negotiations. This was lengthy. This was extensive, and I believe the defendant fully understood it. If you read the transcript, she says she understood it. She says she understands that she could have gone to trial. I don't know how she gets around the fact that she agreed to this. And my client wants to be divorced. It is long overdue that this divorce be entered. Uh, we were prepared the morning of trial. We had subpoenaed people. We'd subpoenaed the CPA that could have brought in all kinds of tax information for Your Honor to review. It would be substantial cost. And if the court were to grant defendant's motion, where would we be? We still have a lot of tax debt, 84 approximately $1,000 of tax debt, and a marital home. We would be nowhere different as far as that goes. I mean,
I'm going to just interrupt you, Mr. Block. I mean, we don't need to, I guess, relitigate or litigate, how we got there, because I was present.
I would just ask finally that you enter and sign the judgment today.
All right. Thank you. And I think these are probably, everything is kind of intertwined. So do you want to respond before I turn it over to Ms. Wolfram to the motion to set aside the settlement?
It's really intertwined.
It is. Yeah.
Yeah. She's saying she didn't knowingly or voluntarily, understand it because of anxiety and disassociation. I would suggest to you, anyone that comes to court on a divorce trial is going to be anxious, and that's not their normal place to be. Of course, they're going to be anxious, but I don't believe that it would be a reason to set this aside. As far as her claiming fraud and misrepresentation by my client for not withholding taxes, again, the tax thing is nothing new. We knew that. The innocent spouse thing was brought up in the September of last year, if not before. All of this stuff is new. There's no reason that I can see to set it aside. She knew what she was doing. She understood it. She said she wasn't happy about it, but on the other hand, she agreed to it, and under oath agreed to it. Said she understood it under oath. I mean, even the court says in the opinion on page, or the transcript on page 7, you even thought it was fair and equitable. There's just simply no reason to set this aside. There is no fraud. There is no misrepresentation.
I just want to correct something you just said, or I think I give you the opportunity to correct it. You said that everything was new. Did you mean everything had?
I'm sorry, not new.
Okay.
There's nothing new in this case. Sorry.
Okay.
Nothing. There is nothing new. She's presented nothing new. This has been known for at least since September, if not last July of 2025. Right. This is all known.
All right. And there also is a motion to adjourn that's pending that that Ms. Farrange filed improper.
I think that motion had to do with the original date that this case was set to enter the judgment, which I would going off memory would be the beginning of May, I think. So okay. It was to move the May date, and you moved it to today.
Okay. All right. So that's been resolved. Okay.
I think that one's moved. Yes.
Okay. Thank you so much. A lot of cross paper being filed here. All right. So I think I've given you the opportunity to speak on all of the pending motions. Is that correct?
The only one left is the PPO.
That's a different case.
Yeah. So
okay. So we're going to take that. We're going to take that separately.
Perfect.
After we get finished with this one. Okay. Ms. Wolfram.
So obviously this is not my favorite position to be in, Your Honor. I hate to, try to Monday morning quarterback, a case. But the more I looked into the information that this client brought to my attention, the more it's not just it's just not unequitable. It's practically unconscionable. She was told that by her attorney, and I hate to have to do this too, and so I'm not going to try to say what she was told by her attorney, but her understanding from her attorney, because I don't know what was said, and I don't want to, accuse another counsel, but her understanding was that that counsel had talked to the tax representative. She was represented, that her attorney had connected with the tax representative, that they had, talked about their individual knowledge, so the legal aspect met with the financial aspect, and that they had met of the minds, and my client was informed, or believed that she was informed, that the tax debt would be joint and several, and that she would have that liability, and that this was her best option. That never happened. So I have an affidavit now from the tax professional that he never had contact with counsel. And so when my client had the understanding that that meeting of the minds had taken place, it hadn't. And that tax professional has now signed an affidavit that I can provide to the court. It came a little later than the deadline, but he has now stated it would absolutely not be like, that is literally what, counsel stated, that the IRS doesn't care who pays. They absolutely do. And that's literally what an innocent spouse claim is about, is that that person would say, I had no knowledge of this. He believes her innocent spouse claim to have substance, and that he believes it's likely to be granted. There's also sort of an
But let me just ask,
Yes.
isn't that something she can still do regardless?
Well, not if she follows through with this, because she'll have paid that tax debt. Well, first things, actually two things. One, no, it would undercut it, because if she files subsequent joint tax returns as the judgment requires her to do, then it invalidates the innocent spouse claim, because essentially she will be filing new joint tax debt, a joint obligation, which she has no knowledge of whether that stuff is now fraudulent, but she'll be waiving that knowledge of whether it's fraudulent. In other words, they'll be reconstructing these most recent tax returns that they have to file as joint. And in doing so, it would undercut her pending claim.
All right, let me just stop you a moment.
Mhm.
Mr. Block, do you have a response to that?
I'm not a tax expert. My understanding on innocent spouse is once the returns are filed and they're not able to pay, then is that, and they issue the judgment or the levy or whatever they call it. That is when the innocent spouse thing would be applied. I don't believe she can do a innocent spouse from a prophylactic manner. In other words, do it ahead of time. That returns have to be filed, the tax amount has to be assessed, and then potentially there could be an innocent spouse claim asserted.
But these are amended, right? The amended one, that's what the judgment calls for her to do, amended ones. That's what I'm talking about.
It would be 22 years. They have not been filed because she refused to sign them for 2022, 2023. The only one that we had talked about amending was 24, because if they filed jointly, they would get a refund instead of an $8,000 refund that could be applied over to the other years.
Okay. And then the second point is, once it's paid, there would be no need to decide the innocent spouse claim, and my client will have paid on the debt that she may have been relieved of from the innocent spouse claim being approved, plus interest, right? Because she'll be paying it with a mortgage under the terms of the judgment. So not only will she have paid that and, maybe then found out or pursued that she wouldn't have to, it's not like she can get refunded. They won't be refunding that. It will have been paid. And my understanding from the tax professional is that they're not going to give it back just because she has been, right? It would be as if she paid it on his behalf. And, then it would, I guess maybe there'd be an option for subsequent litigation to try to be indemnified from it, but it wouldn't, if she, under the terms of this, she wouldn't be refunded that money, right? So if she's determined that it was not her liability, it would have already been paid, but just paid on his behalf and not hers. And then again, plus my client will be penalized with the interest because she'll be paying it with a mortgage that's on the house.
Well, have you shared this? I mean, have you and Mr. Block talked about this?
I did reach out to have a conversation. It did sound to me that he wasn't super interested in that, not, saying that he wouldn't be. He just said that it's time for them to be divorced. And I do agree with this. I understand that it's taken some time. Again, I hate being in the position of quarterbacking, Monday morning quarterbacking a seasoned attorney. That's the last thing that I want.
Let me just say this. I mean, I think, I went into this, frankly, prepared to deny the motion and enter the judgment. I am concerned about the tax issue because even though everybody agreed on the record if there was a misunderstanding in terms of the tax implications, I think that, I mean, that concerns me. So I think what I will do today is I will adjourn. I'll ask that, Mr. Block, you and Ms. Wolfram exchange the information you have. I mean, none of us are tax attorneys. None of us know what we're talking about really when it comes to, so
Fair.
I think it's important to clarify what the innocent spouse, when it's available and how it's available,
Sure.
because I do want to preserve that option. Does that make sense, Mr. Block?
Yeah, I just am unclear what additional information there would be to exchange.
I guess the information about, and the biggest concern for me is the availability of the innocent spouse claim for her. Because I recall we talked about that, counsel and I did in chambers. And I just want to make sure that we have not foreclosed that option for her if I enter this judgment. That is my big concern.
All right.
So whoever you need to, whatever experts you need to consult with, consult with them and get the answer and then confer, and then we can come back. This can be renoticed. We can come back.
Sure. I'll absolutely be
I hate to do that, but I mean, I do need to find this is equitable, and it appeared that way on the face. But I guess I have questions now that need to be confirmed.
And I would get that to right away. I'm not looking to delay it in any sense. In fact, this is a limited appearance, so I plan to get that done as soon as possible, Your Honor.
Okay. All right. So couple weeks?
Sure.
All right.
And just follow up with Tyler for a date.
Well, let me see. When's my next motion day, Tyler? Because I know I've got a conference that's kind of messed up our usual schedule.
June 5th.
Okay. So June, it is next
Is
motion
there
day.
any chance? I am so sorry, but that is the forum, the family law forum, in Traverse, not Traverse Point, the one in Ann Arbor. I was planning to attend that.
The date after that would be June 18th. We are off that Friday.
Oh, I'm available Friday. I can make that work.
Mr. Block, do you have a position on that?
I'd like to stay with the 5th. Perhaps Ms. Wolfram can attend from wherever, Traverse City or wherever the
Can you do it
family.
by Zoom? We'll work with you in terms of trying to get you in either at the beginning or wherever you need to be in the morning.
If I can early, I know I have I'm going to be begging for a Zoom appearance from Judge Gottlieb for a similar thing, but if we can maybe squeeze me in before that, and maybe we can resolve it before that. So
Again, yeah.
I'll be
So
hopeful.
we'll just make a note that we'll take you at 8:30.
All right, I appreciate it. Thank you, Your Honor.
Okay. And again, if you can resolve it before then, that's perfect.
Yeah, no problem.
All right. I think that deals with everything.
Does the court want to? I have no problem with I mean, I certainly can be here, but I'm not of counsel. But if you want, you can use the same session if you wanted to do the next hearing.
Okay.
You want to do that.
All right.
I'm not appearing on that. My client will be pro se.
Okay. All right. Then maybe you just want to step away.
Yeah, I'm gonna just step around, but I'm just gonna finish putting this in my calendar super fast.
No, that's fine.